should time leave to mention an application, my lord, wherein my application for modification of the impugned order was disposed of without hearing, my lord. My lord, this is relating to the promotion of the additional chief engineer in WBACDCL. My lord, there is a bit of urgency, my lord, until and unless that modification is made, or my lord, is it allowed or dismissed, my lord? My lord, we could the entire promotion
You
criteria.
said it has already been disposed of.
My lord,
Then
it is being disposed of, challenging that we have come up before your lordship, my lord. My lord, will kindly allow me and take this up, my lord. There is a bit, the entire promotion procedure of
the rising out of WPST.
no, it is arising also of WPA, my lord. The entire promotion process has been stalled. I'm grateful, my lord.
Give
Lots of new application group 6.
after 1 week.
New application for group 6 lots. If this is
Give the inclusions, all of you give. Whoever wants the matter to be included in the list, you please give.
get lots.
My lord, may I permit you to basis on urgent action, my and because my lord, I have moved before the honorable Justice Subrata Bhattacharya, he directed you to move this matter before this bench, my lord. As because it is a in addition to the recruitment process of constable of West Bengal Police.
Yes.
And I am not getting the admit card. And my lord, the date is fixed for written examination on 30th November.
So you have to file a writ petition. Why are you here?
My lord, I have filed a writ petition before Group 6 bench, my lord, but he released the matter as because this is a bench pertaining to this bench.
How we can take up? There is some confusion. You find out how we can take up the writ. This is appeal arising out of writ, not writ petition.
My lord, as because the state administrative tribunal is not functioning, my lord.
Oh, so it is you have approached the state administrative tribunal.
I have to approach for then I can came before this.
What is the issue?
Issue is that, my lord, I am not getting the admit card for some reasons, my lord. But my lord, the date of written examination is fixed on 30th November 2025, my lord.
30th November.
Tomorrow or today, my lord, I'll.
You give notice, then you give notice. You give notice. Who is appearing for the state? Who will appear?
You give notice, my lord.
Give it. It will come on 29th.
9.
Today is 27.
Saturday, my lord.
28. Tomorrow it will come.
My lord, may I have your kind leave to mention one injunction stay application, my lord, in connection with one FMA of Group 6, my lord. One stay application, my lord, in connection with one FMA of Group 6, my lord.
Yes. Give next week.
Original side, new applications, item number 1.
My lord, I appear for the appellant. In this matter, my lord, what happened, my lord, in this matter, the writ petitioner respondent number 1 also filed an appeal, my lord. So on the last occasion, there was an order by the Honorable Coordinate Bench, my lord, to take up both the matters together. If your lordship kindly goes through the order dated 31st of October 2025. So my appeal has come, their appeal has not come.
It's not come yet.
My lord, I have an application, my lord, under section 5 for condonation of delay. If your lordship please to, my lord, direct to allow this section 5 and to direct the matters to be taken up together.
This is by the ECL.
Yes, madam. This is by ECL. The repetition also has filed a appeal, my lord. Subsequent to my appeal, my lord.
How many days are of this?
26 days delay, my lord.
We'll allow this and we'll direct for that to be listed along. It has, you have received copy of this. Yes.
Original side appeals from orders, item number 2.
My lord, I am appearing on behalf of the appellant, your lordship. As per the last order, your lordship, this matter was supposed to be listed on 5th of February. So I'm only praying the matter can be listed as per your convenience, your lordship.
I am for the respondents, writ petitioners.
Yes. We are
Original side appeals from orders, item number 3.
Alright, item number 3. Two applicants. Put together, out of them order. My appeal is before your lordship. Their appeal is APOT 43 indicated in order dated 31st October. My lord, kindly look into order date. Order date. October 2025. APOT 243 is not before your lordship.
you are appearing in 55
55 is my appeal.
and you are for the appellant in the other case. As per the earlier order.
তাও দেখছি একবার।
Item number 11.
I am for the petition in this matter.
But I am appearing on behalf of Public Service Commission.
Well, kindly come to my lord, volume number 1, paper book, page number 37, the advertisement on the recruitment. The crux of the matter is that petitioner at the Polytechnic professor, my lord, in the school, my lord, contractually appointed on the sanction post, my lord. Now, my lord, kindly see page the advertisement. But on the last occasion, your lordship was pleased to give me direction that the type copy of the advertisement. Page 37 of the paper book.
193.
Walk-in interview will be held at Shiliguri Government Polytechnic, Shiliguri at Central Calcutta Polytechnic. Just. An advertisement mal at page 37A, dated 8 November 2007. The petitioner participated in the interview process.
ST 193.
Here. Subsequently selected my lord, page 38, the letter of appointment, my lord. My lord, 13th February 2008, issued by the Department of Technical Education and Training. Page 38. May I read the notification? The governor is pleased to appoint in terms of the Regulation 7 of the West Bengal Public Service Commission exemption from consultation regulation 1955. The following 31 numbers of candidates in the post of lecturer in the government polytechnics on contract basis with the consolidated pay of rupees 14,980 per month without any allowances for a period of 6 months from the date of their joining from the present or till the post are filled up by the regular candidate selected by the Public Service Commission West Bengal, whichever is earlier and to the post until further orders with effect from the same date as mentioned under column number 3 and 4. Thereafter, my lord, the name of the petitioner, there are 4 petitioners, their name of the petitioners are featured. How can they come to my lord? Straight away, the renewal, time to time, their service is renewal. Well, kindly see page 46 once. Was made again on 4th November 2008 by the Joint Secretary Government of West Bengal Technical Education and Training Department. The governor is pleased to appoint Sri Devasri Polli, the petitioner number 1 before you, to act as a lecturer in modern office practice and management of government polytechnic on purely contract basis for a period of up to 31st December 2008 with effect from 16th September 2008 or till the post is filled up by the regular candidates selected by the Public Service Commission West Bengal, whichever is earlier. In terms of the provisions of the regulation of West Bengal Public Service Commission exemption from consultation regulation 1955. Thereafter, my lord, kindly come to page 119. My lord, 119 page, my lord, this is a extension order of dated, my lord, 2020. Page February 119. 119. Further extension were made by the respondent authority in the case of the petitioner along with other professors. And kindly, this is the notification and same guideline it was issued 190.
Yes.
The list of persons annexed here to are engaged afresh to act as lecturer in government polytechnics as mentioned against their names on purely contract basis for a period of from 3rd January 22 to 2020 and 31st December 2020 or till the post filled up by the regular candidates selected by the Public Service Commission West Bengal, whichever is earlier. And then my lord, kindly come to next page 120.
So in between 46 and 119, there is no extension.
Extension were made, my lord. I annexed, my lord, the extension were made.
It is continuous.
Continuous.
One after the other it is.
Yes, yes. And kindly see them on page 120.
Yes.
The name of the petitioners are featured in the list.
Yes.
Thereafter, we made a representation before the authority, which is at page 135 for regularization.
100?
135.
Yes. So
The representation addressing to the Secretary, Department of Technical Education Training, dated 25th February 2021, by the petitioners before your lordships, saying that this is a representation for regularization. Thereafter, after
Actually, Krishna.
yes. Yes, yes.
My lord, will kindly take this up to come to the order of the tribunal. Tribunal found that we are entitled to be observed.
Volume 2.
Page volume 1.
LP11.
Volume 2.
Two.
219 page. My lord will kind enough to turn to page 222. Pagination milbe ki milbe na? Abar the paragraph starts. It is also to be appreciated
বলো যাবো মামলা চলছে আপনাদেরই মামলা চলছে
114.
that not only their appointment were purely on ad hoc basis, but such appointments were accepted by the applicants without protest. Unless the terms of any appointment are modified, the applicants continue to be guided by the same wordings of the appointment letter. Engagement and continuation in the same post on ad hoc basis does not automatically confer any right upon the applicants. However, the tribunal would also clearly emphasize the other side of the issue, which relates to action by the respondent department. It is the aspiration of the employees engaged on contractual or ad hoc basis to be absorbed permanently in regular establishment. It is their expectation that having served satisfactorily, the responding authorities will absorb them in regular establishment. It would be unfair on part of the applicants to continue serving ad hoc contractual basis endlessly. Some of the applicants have been serving in this post as lecturer on ad hoc basis since 2009 and have completed a major part of their service life. such post of lecturer in government polytechnic colleges cannot and ought not to continue on ad hoc basis. The responding authorities must take concrete steps to fill up this post on regular basis, either through absorption or through fresh recruitment process. Therefore, a direction is given to the respondent number 2, the additional chief secretary, and training to initiate concrete steps in filling up the vacant post of lecturers, either through absorption of these contractual lecturers or through fresh recruitments. Then factually, our continuation on a sanctioned post was found by the learned tribunal, but learned tribunal felt constrained that since you are named as ad hoc, therefore you continue as ad hoc. Well, law is not that. Law is now well settled. On the last occasion also that I had placed the recent judgment of the Honorable Supreme Court. Lordship had the kind consideration to that and asked Mr. Mukherjee to give appropriate reply. This is 2024 SCC online, Supreme Court 3826.
Jago case. After that, Dharamveer has also come.
After that, following the same principle, Dharamveer.
Dharamveer.
Yes. Dharam Singh, that is Milord.
Dharam Singh. Something like that.
In effect, Milord, this is now settled. Even Umadevi says that you cannot really continue some persons to work years together unless the initial appointments are illegal. You have to absorb them. Our appointments are not illegal. Upon advertisement, upon proper contest, they're lecturers. Jago Downi? You have to take it. This Dharamveer, the Jago was considered. That in Dharam Singh, paragraph 11, towards the concluding part, the Jago is referred to. That the succinct observation in paragraph 17, if your Lordship takes the trouble to come. May I read paragraph 17 loudly?
Just give us some.
Yes. Dharam Singh. Dharam Singh to be দিয়েছে। Remember the fine.
Yes, 17.
Yes. I am tempted to read this. Before concluding, we think it necessary to recall that the state here, referring to both union and the state government, is not a mere market participant but a constitutional employer. It cannot balance budgets on the backs of those who perform the most basic and recurring public functions. Here, they're all teachers, lecturers. Where work recurs day after day and year after year, the establishment must reflect the reality in its sanction strength and engagement practices. The long-term extraction of regular labor under temporary levels corrodes confidence in public administration and offends the promise of equal protection. Financial stringency certainly has a place in public policy, but it is not a talisman that overrides fairness, reason, and the duty to organize the work on lawful lines. Moreover, it must be necessarily noted that ad hocism thrives where administration is opaque. The State Department must keep and produce accurate establishment register, master roll, so and so, and must explain with evidence why they prefer precarious engagement over sanctioned post where the work is perennial. If constraint is invoked, the record should show what alternatives were considered, why similarly placed workers were treated differently, and how the chosen course aligns with Article 14, 16, and 21 of the Constitution of India differently. Sensitivity to the human consequences of prolonged insecurity is not sentimentality. It's a constitutional discipline that should inform every decision affecting those who keep public offices running. Having regard to the long undisputed service of the appellants, the admitted perennial nature of their duties, the material indicating vacancies and comparator regularizations, we issue the following directions. The directions are issued to regularize them. Here also, when the tribunal found that this sort of continuance of the teachers and the lecturers on ad hoc basis is not expected. But
No, they were not teachers.
lecturers.
Here in this case.
No,
Dharam's?
not our case.
Yes.
Case before my lord. In that case, they are not lecturers. They were not workers.
Yes. You have given us the other judgment also. Judge.
Yes. That is there. Hey, they can do Joshua work in the
Yes, it is there. We have seen it. Now it is reported also, Jago.
But these are all reported. This is SCC online report.
That's all.
May I take leave of that?
Yes. Yes.
Selection by the PSC or job secretary. And another that to follow. Similar question, similar identical facts, identical came up for diction bench. Because of the finding by the diction bench, that because of the issue obtained from this no selection, they would have started selection. They have some of them participated, not qualified. And
These petitioners.
some of the petitioners, not all.
Where is the earlier order?
I see that page, order of justice. 180.
One 107 of 2016. WPST 107.
Identification.
No, it is regarding the same or it is similar? Same.
Same.
And some of the writ petitioners are parties in that proceeding.
No,
They are separate.
they are separate. Now, what are the different means of our IPO? Rejected the visa questions on the other thing. So because for a 10 years qualifying service on the date of judgment 10th April 2006. And for NLKC, yes, but yeah, they were appointed in 2009. And for Jacko, they were appointed in 1990. That means in 2006, they are qualified 10 years qualified. First, and when the Jacko is a transport staff, and when the lecturer at the college must be have some qualification and must have a AICTE recommended qualification recommended. First product factor aspect, Jacko appointed in 1990. Factor lots to try for Jacko's case at page paragraph 4, 98, 90 and 93. Appointment number was appointed 93, appointment number supplied was 98, appointment number supplied 99. And other things 1992. Am I clear to you?
Yes, you are clear, but the point is, how do you distinguish the paragraph which has been relied upon by them?
No, every judgment has to be
So it is in these facts.
fact. Because their appointment, officials appointed in 2009. That means in 2010, only 1 year something. As you for a moment, 2 years. But Supreme Court said, paragraph 53, 10 years, continuous service without interruption. When we are going to select the person, they approach them. Then after in water, we could not complete. Then subsequently we started selection process PhD. Started. Page 194. So 195.
Just 1 minute. February 2008.
They are continuous.
Just give us a minute. 2008 for 6 months. So it ends in August. February 6 months, ends in August. See page 46. September. Every time. All the renewals which they are relying upon, is there a gap in between the renewal of contract, or does it make it continuous?
Sometimes there is a gap, there is sometimes no. That's it. No.
That is an issue of fact. Refer to the two orders. Come to page 38 and 46. It's not something which you can make a submission like that. 38 is issued in February 2008 for 6 months. That means it comes to end in August. When did the next contract start?
It's 51. This is a notification dated extension, notification dated 6.
No, 38 and 46 first.
Thereafter. Page 51. There's a notification of 2011 extension. Thereafter 2053, 21st February 2012. Same process. Extension were
For 6 months, that means it ends in August. Page 46. No, but with effect from September. With effect from September. So, and the subsequent renewals, where are the subsequent renewals?
page 51.
After 46, it's 51.
46, then 49, 6 January 2010. Then 51.
So this page 46 is for 6 months again.
6 months.
47 with effect from 30 June 2009. Effect from 5th January 2009.
Continuous. Kindly see page 51, 53.
Which one more doesn't
54 and 55, kindly see. 4th January 2012 with effect from thereafter next notification 7 January 2013 with effect from 4th January 2013. 54, 55.
And how this there are two notifications at page 46 and 47. How do you reconcile these two notifications? You see at page 46, you will see that there is a name appearing at serial 2. Now that, just so there is a name appearing. This is of, please. This name appears, this notification is of November 2008 for 6 months. Is it for 6 months?
Is 6 months up to 31st December 2008.
31/12/2008.
Effect from
How is it? Then because you see the next page, it is more inconsistent. Next page is the notification of February 2009, just after 3 months. So are they being engaged in different colleges, different as per requirement, wherever it?
different colleges, because
How do we know? How do we know?
kindly see my page 119 once.
No, how do we know? Page 46 is for which college?
Sir, a list is given by page 120. My lord, I am submitting before last year only. Page 120.
First, let us see. Come to page 46.
46.
This is at Women's Polytechnic, Calcutta. And what is the college in page 47? Women's Polytechnic, Jodhpur Park. So it is different.
Correct. The name of the institution is given by the size.
No, we want to know for sure.
Yes.
They are not, they are being engaged as per requirement in the different colleges. That is your case? Is it stated anywhere? Or based on this?
In original application, that has never been stated. In original application, we have already annexed the extension order.
But it appears that it is, because otherwise these will not reconcile with each other. If there is one appointment for a particular institute for 6 months, where is the occasion that after 3 months a fresh order has to be issued? But we don't know whether this Women's Polytechnic Kolkata and Women's Polytechnic Jodhpur Park are one and the same, or they are different.
Instruction. Institution and Women's Polytechnic, same institution.
Then why these two orders are issued within 3 months when the appointment is for 6 months? No, you are the beneficiary. Therefore, we are asking you, what is the circumstance? Why? What is going on?
Same institution. I'm just instructed. Same institution.
Then you see, then there is no occasion for issuing this second notification after 3 months when the appointment is for 6 months.
Again on 6 January 2010.
Exactly. Therefore, we are saying we would like to know what the fact is.
kindly see the wording, kindly see the pure contract basis for a period up to, not, there is no mention about the 6 months. The period is mentioned.
Yes, so 31/12/2008.
Yes.
Oh, so this was not for 6 months. For a period up to 31/12/2008. No, not for 3 months, for hardly more than 1 month. From 4th November to, maybe from September to December. September to December.
That's why I'm
And then there is a fresh engagement in February.
February, 13th February 2009.
And this is with effect from
Effect from
January. With effect from January.
31st December 2008, thereafter 5th January.
So as per Can you give us a one sheet in
Make an Excel sheet.
on chronology, the extensions for how many months it has been for any one petitioner? Unless there is continuity, whether you can rely on the judgment, therefore we are
We
saying.
have all extension order, but that has not been annexed. All order has not been annexed. I can prepare.
What, you have filed a reply in the tribunal? Where is your reply?
That page, LEC page, reply page 151, second volume. And we come to paragraph E, the main contention of the respondent of it. Were engaged after the cutoff. That was the main prime contention.
And where is that judgment of the coordinate bench that you were showing?
188. 188. Kindly consider paragraph 7, page 193. The factually it is different from our matter. There, my lord, the petitioner seeking benefit of the, my lord, 10-year service prior to the cut-off date, as enumerated in the judgment of court.
No, but Uma Devi, whether it has been overruled in Jago or Dharam Singh.
Kindly see paragraph 26 of the judgment, my lord, it passed in Jago matter.
Yes. Yes, so that it is not in any way interfering with. It is saying that it is often misrepresented. It does not say that that we say that the earlier view was not correct or
Not that, but every time, my lord, the government respondent, my lord, cannot take the stand of Uma Devi.
that we have understood, that you are saying, but what we are saying is that the requirements of para 53 of Uma Devi, that has not been diluted.
Absolutely not. But my lord, in every time, my lord, every matter, my lord, they cannot take the same matters. Can prepare an Excel chart, my lord, showing the extension in respect of all the petitioner, because, my lord, the date of, my lord, extension, my lord,
No, we have seen now, it is not important. They have in their reply, they have explained that circumstance. That is not in dispute, that they have been repeatedly engaged on contractual basis.
what has happened, my lord, that the coordinate based judgment, my lord, factually, my lord, different from our.
No, but it's for the same post.
Same post, factually
Yes.
different. There, my lord, the similar circumstances candidate, my lord, seeking benefit of Uma Devi judgment, my lord, because, my lord, some certain candidates are given benefit.
Ultimately, you also can be granted benefit only if you fulfill the requirement of Uma Devi.
We are seeking, my lord, regulation on the ground, my lord, continuous service, absolutely continuous.
Correct. So,
And, my lord,
continuous means at least 10 years. Below 10 years, it is not possible.
my lord, since, my
Because
lord,
the two judgments that are being relied upon by you, in both those cases, they are working for decades.
99, my lord, 99
For
they joined, my
decades.
lord.
Yes.
99, my lord,
You're-
2006. The cutoff date, my lord, 10th April 2006.
That's not the point. Not
10
till
years not completed.
whether till date of judgment or after. That's not the point. The point is 10 years without an order of the court. Even if you may be in a position to say, even if after the judgment, the 10 years is completed without aid of a court's order in view of the subsequent, that we understand, but 10 years cannot be diluted. Because neither of these judgments says that requirement is to be diluted. The subsequent judgments are on a different footing, that state being a model employer in a welfare state, whether you can do this, resort to ad hocism when you know the work is perennial, and take advantage of these people indefinitely.
And hopefully tribunal was of the view that, my lord, our service is very much required for the institution.
Yes, so
The observation made by the-
tribunal has recorded, but that order is under challenge by you.
the last part regarding advertisement.
So those observations of the tribunal has resulted in a conclusion that yes, the work is of such nature that it is desirable appointment should be made, whether by absorption or by open advertisement. The both option has been given. You have challenged by saying that no, there is no question of regular appointment, you must absorb. Otherwise, you would not have challenged. So whether that discretion can be interfered, we will see. Not required.
Date, my lord, we fixed for reply by my senior. Next date, any date. on the issue, my lord, because, my lord, they are, my lord, have much more, my petitioner, my lord, much more.
Then if we are adjourning, then you give the Excel sheet. If you want adjournment, then you give the Excel sheet. We thought we will close it today. If you want a reply, then you can give.
Give by my lord Tuesday. Within my lord 4-5 days I can prepare.
No, it will come on Thursday.
First.
The learned
Already my lord
2 p.m.
2 p.m. 2 p.m.
Oh, just some.
Yes.
So when should we have it?
What?
No, because this is WPST. So it will come on Monday or Tuesday, 8th or 9th, whatever you want. 8th. Two p.m.
Right.
The next is the same.
Same. Man. Get man.
Item number 1.
Praying for short Passover. Instruction. But I'm appealing for code number 2 to 5. I'm led by Mr. Shivshankar Banerjee. He's on his legs at code number 36. I'm praying for short Passover, my lord.
But it's my turn to reply only. Lordship, may kindly recollect, my lord, this is that matter. I am not the authority under which my husband was working, my lord. I say that I preferred a writ petition by saying that I am not given with the proper, my lord, retirement death benefits. So, my lord, the writ petition was dismissed by the Honorable Single Bench by saying that it is not maintainable since it is not a state under Article 12 and, my lord, cost was imposed on me. So, my lord, against that, I prefer this appeal. So, my lord, my bone of contention, your lordship, I'll just briefly, my lord, state your lordship because I will not repeat this because, my lord, it is only with respect to, my lord, that the point that the rule of the SAIL was applicable on my husband's employment. So that rule, my lord, is a statutory rule. Since that my husband's service condition was being guided by that statutory rule, the writ petition should be maintainable. So, my lord, I was relying upon Saint Mary's judgment, my lord, a specific paragraph on that only.
Yes.
So, against my submission, my lord, my learned senior, my lord, on the other date, my lord, concluded his argument. He, my lord, took a specific point that there has been, my lord, the judgment of the Honorable Delhi High Court with respect to the same institution, holding it not amenable to the holding it not.
Two documents you brought by way of additional evidence. You wanted that was not considered. We remember.
Yes. So, my lord, I'll not repeat because I know, my lord, lordships, my lord, hate repetitions. So only, my lord, I just.
But what it was adjourned for? For some specific.
For my reply. Because after my argument, my learned senior's argument was over. So it is my turn to reply.
Yes.
So my reply to my learned senior's argument only here, my lord, with respect to that judgment of the Honorable Delhi High Court single bench, my lord, which my lord, I only say, my lord, that particular lordship has seen the judgment, Honorable Single Bench. So that judgment was with respect to whether the institution was on Article 12 or not. So, my lord, this particular point that whether the service condition of someone's is by a statutory rule or not, that was not even considered. It was, my lord, the principle of sub silentio, my lord, should be, my lord, come into play. So, my lord, I say that that particular point was never taken by that honorable, before the honorable bench, and that was not considered. And second, my lord, in reply to this, my lord, when this particular judgment was passed in 2015, but before the honorable Delhi High Court,
Yes.
my lord, the Sagar Thamas matter, my lord, was there in force, where, my lord, it is specifically stated this rule, which, my lord, now the Saint Mary's, my lord, postulates about, my lord, the this service condition being guided by a statute. Then
That you have placed on the
so,
last day.
Sagar Thamas, my lord, that judgment was there in the field when this Delhi High Court, my lord, passed the judgment. So that also was not considered by Delhi High Court. So, my lord, Saint Mary's has been passed, my lord, after the judgment of the Delhi High Court. So this is why I was saying that that was not considered in Delhi High Court, Sagar Thamas. So only
See, the only thing is you have relied on two documents
yes,
which you have annexed in your additional evidence.
Yes.
You say, looking at these, the inescapable conclusion is that sale rules will apply. So it is, if it is sufficient to make out only if such a rule applies, then only a writ can be issued. Whether you rely on this judgment or any judgment.
absolutely, absolutely. This is only my contention.
Yes.
So I only said that, my lord. And if I could, my lord, I know that, my lord, what happens, my lord, in this, there was, my lord, another litigation, my lord, that was going before this honorable court, my lord, with respect to this particular institution. So, my lord, in that review matter, it is a review, my lord, pending before the another honorable bench. So there, my lord, some documents, my lord, they themselves, my lord, disclosed, where, my lord, it is like evident. They themselves say that yes, the rule of the sale only applies to us. But that is not before your lordships. That is not before your lordship. If I, my lord, I know, my lord, this is a stage of my reply to the argument that is against of my lord senior. If I could, my lord, bring those documents, my lord.
Oh, no, surely not.
Yes.
That is an issue to be decided in
Yes,
that
yes.
case, not here.
Yes, my lord. So that document was relied upon by them. Be that as it may, my lord, I did.
You have already adduced additional
Yes.
evidence.
So this is all my submission before your lordship, that if that particular was there in that event, my lord.
All right. Sagar Thomas judgment, where is Sagar Thomas?
Sagar Thomas, my lord, I was referring to only two paragraphs, 18 and 31. Sorry. The reason for relying upon Sagar Thomas only is that Sagar Thomas was there when Delhi High Court passed the judgment.
Paragraph?
18, my lord. 18 and 31.
18 and
31. My lord, the citation is 2003, volume 10, Supreme Court cases, 733. So, my lord, 18 is a summing up paragraph, my lord.
Very well.
I just request your lordship, if I just could, my lord, file 2-page written notes.
Oh, no. Why now? What we have made notes of everything you have argued.
Great.
Not required.
Great, great.
Heard the parties.
Great.
Item number 2.
Asked to question. My lord, my learned junior argued the matter before my lord. It was the desire of your lordships, my lord, to file a list of date along with the judgments, my lord, which had been referred. Now, in obedience to my lord's directions, my lord, we have prepared. My lord, whatever your lordships, my lord. A copy has also been circulated.
Let us have a look. We are keeping it under the heading for orders. We'll pass them. List of dates.
December.
Third will.
In this one also.
Item number 3.
Yes. Yes.
Lord, my uncle Gopinath Mukherjee was an employee under the respondent authority, my lord. And my uncle nominated me in his lifetime for service benefits. Meanwhile, he died prematurely at the age of 58 years, my lord, and before his retirement. And since then, I'm entitled to get all his service benefit, my lord. Now, along with my father, I made an application on 17th November 2001 before the respondent authorities.
17 November
17 November 2001.
2001.
1 million. Now they have not released any death benefit on that or replied that on that application. Thereby, I moved an OA application on being number 1010 of 2002 before the learned state tribunal. and thereby pleased to pass the tribunal, administrative tribunal pass an order on 29 January 2008 as per the prayer of the applicant, my lord. But due to the inaction of the respondent authorities, the part of respondent authorities, I moved an contempt application also, my lord.
Where is the order passed in 101?
101.
Where is the order passed in 101? Which page?
29th January. That is not annexed here.
That's not annexed.
Annexed here.
So have you stated anywhere what the order was?
Uh,
What was the direction issued in 101?
to release the all the benefits, all the principal amounts, my lord.
Where have you stated this fact?
I have stated this
In
on-
your OA, show us from the OA where you have stated
Yes,
that in 101 there was a direction to release all the.
my lord, page number 4 of the writ petition. Point number 5. My lord.
No, in your OA, not writ petition. You have to show from your OA. Writ
Wait.
petition is to see whether the tribunal's order is correct or not.
That
So if that fact was there before the tribunal, then only it was required to be considered. Therefore, we are asking.
that is not annexed here, my lord.
Why? Without OA, why you are arguing? How you can proceed with the matter without the OA? Please, yes.
Yes. Principal that in respect of that OA, my lord, the principal amount has been disbursed.
Oh, so you were
Yes.
paid in compliance of that.
Yes, yes.
Whatever they found admissible, they have paid.
Yes, yes, yes.
Then
Interest has not been paid, my lord.
when did they make the payment?
They made the payment on, my lord, by the end of 2009.
2009.
2009.
So this was, you have the date.
Yes, my lord.
What is the date of the order passed in OA 101?
Date of the 29 January 2008.
29 January 2008. And this is OA number 101 of?
But my lord, on that OA, they have not disbursed the amount. I have again filed a
OA number 101
of 2002
So then you filed a contempt.
application.
So what
number
was the CCP number?
50 of 2008.
50 of 2008. Then only they made the payment.
Then they made the payment, but
On 29/1/2008.
yes, grateful. After that, what happened, my lord? Then, my lord, for interest, I file an OA application.
Yes. OA number?
1727, my lord.
1727
of 2009, my lord.
That order is on record.
Yes, my lord.
Which page? Show us.
Page 21, my lord. 18 to 21. Page 20 is the operating portion.
What happened in WPST 69?
Yes, Milord. The state respondent authority being dissatisfied with the order dated 9th October 2012 file and WPST 69.
WPST 69 is
Yes.
dismissed in default.
Yes, Milord. They have obtained an interim order in this writ petition.
Yes, but it was ultimately dismissed in default.
Dismissed in default, Milord. 16th August 2023, Milord. And having knowledge of that, Milord, on 17th October 2023, I have made another application to the respondent authority for compliance of the order dated 9th October 2025. Again, it was ignored, Milord. Now, I went up to the tribunal, Milord. I have filed another contempt application, Milord. That is CCP 82 of 2023, Milord. And in that, the administrative tribunal disposed the matter merely on some technical ground, Milord. And in the order dated 7 March 2025, in the last page, Milord, may I read out, Milord?
Yes.
Milord, another CAN has been filed by the respondent authorities for restoration.
Let them file opposition. You file an opposition. For filing opposition, matter is adjourned. The list after 4 weeks. 3 weeks for opposition and 1 week for reply.
One.
For date now.
Huh?
4 weeks for date now.
4 weeks. हाँ 6 जनवरी को दिसंबर थोड़ा में जन आ जाओ item number 4
Well, item 4, my lord, I appear for the petitioner. My lord, the case of the petition is this, my lord. petitioner before Lordship was an executive engineer. My lord, the departmental authorities, my lord, by a memo dated, my lord, a memorandum of charge dated 28th of May 2025, my lord, 2 pages charge memo was served upon me. My lord, stating that
When it was served?
my lord, dated 28th of May 28/5/2025.
Charge memo was served.
2 pages charge memorandum was served upon me. My lord, thereafter, my lord, all without any imputations, Annexure A, Annexure 1, Annexure 2, 3, and 4 imputations and the charge, the list of documents, as well as the, my lord, the list of witnesses. Now, my lord, thereafter, I received a bunch of papers from the department wherein it reveals the Vigilance Commission, on their own, they have conducted certain inquiry, which is dated 31st of January. My lord, the charge memo is of my lord, 25th of May, and 31st of January was one purported charge sheet, a draft charge sheet, and all other things were given to me. And the vigilance practically directed the authorities, my lord, to make this charge memo, and my lord, they have done it. My contention is, my lord, this entire fiasco that has been taken out, it is on basis of act of dictation, which is not permissible under the law. Now, my lord, I can understand a preliminary inquiry can be taken out only when the department wants. My lord, if your lordship sees the charge memo once, if your lordship takes up the charge memo at page 34, this is the 2 pages charge memo dated 28th of May 2025. Well, I have come before as because the tribunal is non-functioning, my lord. I have no option left, my lord, as because certain other development took place in the meantime. My lord, your lordship will find page 34. This is the 2 pages charge memo which was served upon me by post. Next page, my lord, page 36 is the, my lord, the envelope by which.
What is the law when the court can interfere in a charge memo?
Yes, my lord. Normally, the court should not be interfering unless it is issued by incompetent authority, my lord. I understand this, my lord. Or, my lord, if the charge doesn't speak anything. Now, what I'm on this, my lord, if the charge memo is on behest of a dictation.
Whether, see, you are invoking a judicial review in respect of a charge memo. What is the law? Let us see. Come with the judgment. That's all.
Yes, my lord,
either we are within the scope or we are without the scope.
Understand.
The facts may be something which you may benefit from that in the proceeding. We don't know. That is yet to come. Those are issues which you can raise. You are not stopped from raising those issues. Nipping in the bud. Under what circumstances? What is the law?
I will come with the judgment. If you lordship kindly takes trouble to come to page 37.
You have understood what you are saying. There is no independent application of mind by the disciplinary authority. This is what you are trying to say.
They have given a charge.
You are saying somebody has dictated. We don't know whether these circumstances are to be interfered with in a review, in a judicial review.
I understand. This not I will come with the judgments, not subject lordship kindly.
That is all.
If you lordship kindly, for my satisfaction, kindly takes trouble to come 37 once.
We are looking at it. Therefore, we are saying these are proposed departmental proceedings. This procedure is not unknown in law. It is very much done in almost every department.
The CVC itself, the SVC itself, my lord, gives the name of the inquiring authority, the presenting officer, and the charge memo.
What is unique? It is happening in almost every case. That is the procedure. They are an aid to the departmental proceeding. Now we have gone through the manual.
The manual says, my lord, if a lordship, I have.
So therefore, but we don't, whether this is an issue to be examined here at the stage of charge memo. That is the issue.
My lord, then that's the situation, my lord. I have got one manual of 2012. My lord, one few pages.
There may be a procedural, we don't know. It will benefit you in the proceeding. On that ground, whether we should nip it in the bud. That is the issue.
No, my lord, what has happened, my lord, after filing of this application, the copies have been served. My lord, they have done, my lord, I may think, my lord, I may say, my lord, subject to kind leave. But if they found something is fishy or something may go wrong, my lord, what they did, my lord, now they want to proceed criminally even. My lord,
they have the option. Why not? What prevents them?
They both can do it, my lord. But it should not have been, my lord, after the filing of the application when the matter was taken up by the.
Why not? What prevents them? If a disciplinary proceeding is challenged in a court of law, they cannot move for a criminal.
No, I will never say, my lord, they can.
They can. What is the illegality?
Both can move simultaneously.
Not simultaneously. At any time, they can lodge an FIR.
The thing is,
They
my lord,
can lodge a complaint at any time, whether when the matter is pending, when it is not pending. What prevents them?
even in that letter, my lord, the CVC directs.
And the scope of this civil jurisdiction, whether it will prevail over the or
No, my lord, I'm not saying, just, I want to show, my lord, the intention of those.
they must be very eager to get you to answer things. We don't know what will ultimately happen. We are not saying that you are, we cannot at this stage say that you are to be held, the charges are to be held, proved. It may be a false implication, we don't know. But the fact that they are eager to bring you to justice, what is wrong with that?
The only thing what I'm researching is this, my lord, the 2012 the circulars, which was by which Vigilance Commission is now been, my lord, yesterday I've been told that it's handed over to your lord.
Yes, therefore we are saying.
Well, that
it's very
circular
clear.
also says this preliminary inquiry can only be done by the on the instruction of the department itself.
We don't know. We are not going to look into all this at this stage. We are not going to look into all this at this stage. These will be facts available to you in the proceeding. You can always raise these issues.
Well, then, my lord, I believe I have got one judgment with regard to punishment part. I do have the judgment. My lord, then just lordship grants me 2 days time. My lord, let me search out any judgment with regard to this sort of things exactly. More or less parameter with my case, my lord, if I can find it out. But I have a judgment.
Whether why we are thinking out loud for a very specific reason. Do you want us to record a finding at this stage? Very well.
If I do not find anything, I will withdraw it. I will never say about.
Therefore, we are saying, all right, as prayed, list on Monday.
But if I find, my lord, nothing, my lord, I will surely withdraw.
No, we are
Sure,
just
lordship
see
passing,
when there is an interaction, you are in a better position to know. Therefore, we interact. Otherwise, yeah.
Item number 5.
Service is not required, madam. Service is not required on the first day. We can proceed without service. Huh? As prayed. List on Tuesday. Give the date, Tuesday.
Second December. 2nd December.
Item number 6.
So I appear for the petition. This is the certificate copy. This is my original certificate copy. My lord, without with leave, my lord, I filed this writ application with the server. This is original certificate.
You file it just like this.
No, this should not be, my lord. That
then why are you doing it, sir?
I put notice to the honorable court, my lord, that this I obtained.
Is this the way to file the certified copy?
It is filed by the department.
Yes. It has to be attached with the file. File it today. We'll proceed. The Xerox copy is there.
Xerox copy is there. Online copy is there.
Learned advocate for the writ petition.
It for the age relaxation. My lord, he has already, my lord, obtained an order in the year of 2021, West 69 of 2021, for consideration of the participation of the, my lord, the selection process. That is kindly come to page 30. That is the result is, my lord, pending before the, my lord, the authority department. Result has not been published. Against, my lord, advertisement has been, my lord, the published for the fresh recruitment. My lord, he has, my lord, wanted to, my lord, the participate in the fresh recruitment. My lord, tomorrow is the date fixed for, my lord, the last my lord, the filing of the form. That is, my lord, the advertisement I have been annexed. Kindly come to page, my lord, 31. That for the purpose of the medical technologist post of, my lord, the health department group, grade 3. Family welfare department grade 3. Medical technologist, family welfare department grade 3. Page 31 is the advertisement. My lord, lastly, my lord, he has always, my lord, the contractual basis engaged time to time, my lord, by this order of this, my lord, the tribunal, as well as my lord, the order by the authority. Now again, my lord, he intends to participate to, my lord, the selection process on tomorrow.
Who is stopping you? Who
My
is
lord,
stopping you?
my lord, stopping, my lord, that is the 28, my lord, the learned tribunal, lastly, my lord, the result has not yet kindly come.
Who is stopping you?
My lord, age relaxation, my lord, I am overage.
So
The different, my lord, that order passed by this money in favor of the petitioner to participate is the process. That is page 30 is the, my lord, last order. That is passed by the tribunal. This is, my lord, the first order. That is kindly দুটো দিয়ে দিন তো order টা। Page 30. 5th August 2024, that is submission of the learned councils appearing for the both sides is that now since the applicant has participated, direction may be given to allow the respondent side to publish the result, including the petitioners. With the above observation, tribunal allows the respondent number 3, the secretary controls the West Bengal Health Department, to publish the result of the recruitment was held for the post of medical technologies P&O grade 3, including the result of this applicant within 30 days from the date of communication of this order. And as application is disposed of, result has not been published. Again, my lord, the advertisement has been published. My lord, kindly come to page 31.
So how this helps you? How this order helps you? There was a process in 24. You participated. Now there is a fresh process. So what is to be done?
My lord, this is the new recruitment process has been going.
You are claiming age relaxation under what authority? What is the basis on which age relaxation is to be given to you?
My lord,
Why?
Contractual, my lord, the employee.
You may be.
My lord, that is, my lord, different orders, my lord, I have been, my lord, engaged by the contractual basis.
You may have been. You may have
Lastly, my lord, I have been engaged. Kindly come.
What is your right to get a age relaxation? What is your right?
58, my lord, the Shankar Mondoli is also, my lord, is allowed in the year 10 July of 2025. Is directed to engagement phrase contract and also the Honorable High Court. এখানে আছে page 15. Yes, 27 by the order. This court also, my lord, observed. Page 27.
You have not annexed your way also.
Now, way, my lord, that I am leave to, my lord, to file this way application to, this is, my lord, the way application I have been, my learned friend is make ready. This is, my lord, I am gave leave to file this way application. Well, I have not been collected at the time of filing of this way. My lord, order has been passed on the 20th, my lord, matter has been fixed, my lord, the 26 May 2026, 28. 18 May of 2026 for admission hearing.
First. Very irresponsible way of filing a writ petition. We are deprecating this every day. Very irresponsible way of filing a writ petition. This is not expected that you will withhold documents from the court. On this ground itself, it is fit to be dismissed.
Judgment has been overruled by the. Or I think.
order আছে honorable.
He was of that age.
What happened in that recruitment process? You did not compete. You have got your
Online,
chance.
my online submission has been not.
No, in pursuant to OA 69/20
69, no. This is not published.
cannot be given to you every time. You have got it once.
Second chance.
Yes,
Unless
heard.
my result is being published, I'll be.
No, that is your case. Come. Today.
Item number 7.
Lordship, in item number 7, I beg to appear online, Lordship. There was a direction to file compilation
Both
of
of you are
judgment.
submitting at the same time. Your learned advocate here is also submitting and you are also submitting. Yes.
And for the petitioner, my lord, led by Mr. Fiddosami, senior advocate.
We can't hear you. Please use the mic.
Senior advocate Bikash Ranjan Bhattacharya and Fiddosami are appearing before courtroom number 17, my lord.
Yes.
For that reason, I'm praying for a not today.
All right.
Lordship, I have already filed the judgment compilation, Lordship. There was a direction to file within a week, Lordship. Regarding revaluation, Lordship directed to file
A prayer
compilation
is
of
made
judgments.
for adjournment on behalf of the writ. Or let it come on 15th. 15th. 8th also we have fixed to minimum. 15th. Yes. 15th. The compilation has been filed today.
No, Lordship, on 24th, I have filed the compilation with the court officer, Lordship.
So it is there in the file. All right. It is there.
Lordship, I'm grateful, Lordship.
Item number 8.
Petitioner, my lord. On last occasion, my lord, there is a direction to file affidavit, my lord.
Opposition.
Opposition by the state, my lord. Already one opportunity was given and PSC has filed, my lord, their opposition and thereafter reply. My lord, after on last occasion, my lord has asked specific question that.
Yes. There's a specific query why you have not filed the opposition.
I don't know.
No, last day on 6th we had asked you.
But the query I told you, affidavit regarding that query. Because of section 36 of the Disabilities Act. If it is not available, particular post, they carry forward. In the next vacancy advertisement, you should have to give reason to carry forward the general candidate.
Why don't you place it on record? Time for filing the.
My lord. Computer-based test will be conducted on 31st December of this year, my lord. If the vacancy.
Therefore, after 1 week, what is the harm?
Vacancy.
Yes.
Any interim protection, my lord, maybe.
31st December.
We're in November.
Yes.
আপনি করে দিলেই হবে স্যার।
After 1 week. 8. Give the date. Tell her the date. 8.
Item number 9.
Time for the petition in this matter, there is a direction to file paper book as well as a supplementary evidence.
Yes.
Paper book and evidence. book is not.
All the respondents are appearing.
So the five-way respondent is not appearing, never appearing, my lord, and this is, my lord, you will have to kindly see the order, my lord, you will have to the order.
Where you have said that it was refused.
Envelope
In your affidavit, where have you said that it was refused? Then why?
annex the postal receipt only.
So
In that case, may I come back now with another service?
why do you file an affidavit like this? Either you stand by the envelope or you don't stand by the envelope. If you stand by the envelope, you must say so. This is not the way. How can we record? On affidavit, you are not saying it was refused. You say, look at the envelope, and by looking at it, we should record refused. Then why are you shy from saying that fact in the affidavit? And you have given 2 copies. He is not saying return. It says return and here it is. It should be showing in the tracking report also.
They are not often in track report.
Why, sir? Why?
The article was that
So you at least make that a statement in your affidavit.
that is what our followed by.
And you, it is better if you give the tracking report also.
It is not been possible to obtain the track report because it was not available.
Anyway, if it is not possible, you say that at least. Otherwise, how we can record that there is a refusal? In the affidavit filed today.
May I just
taken it. We have taken it.
15 বার
That he will give. That he will give. 15.
15
15. Develop.
item number 10
And I appear for the petition.
Yes. What is the date of demise?
My
He is your father or husband? Father. Date of demise?
yes.
Please give the date and please give us the post from on which he was working.
But I think your lordship has taken the note of this because this matter was heard extensively, at least 4-5 times.
There is one date on which it was heard, 7 July 25.
But 2nd of October 1992, my father expired.
Yes. And your mother made an application?
Yes.
When?
My mother made an application on 15th of February 1993.
Yes. At that time you were a minor.
Yes, I was a minor.
When you attained majority?
But
When did you attain majority?
Can I give you one minute? But I, for the first time, made the application 2017.
No, when you attain majority, that will be a relevant date.
Give
Therefore.
me another 1 minute time.
Yes, yes. Take 2 minutes, but give the date.
For so many days, I have forgotten most of the things.
Two 2007,
মনে হচ্ছে
page 21.
দেখছি
Why affidavit?
আপনার affidavit আছে না?
He attained majority in 2007.
2007.
2007.
And he applied.
28 January 2007.
So what happened? It was rejected. When? Is the rejection order there on record?
Yes, yes, yes. It is there.
Can you give us the page number?
Let kindly turns to the affidavit in opposition filed by the state.
Yes.
Page 43, page 41.
That is the rejection order.
Yes, 41, 42, last page, 43.
5/7/2019.
No, it is 9th September 2024. The government's inability to approve the submit করতে বলুন। Oh. Page 56 of the writ petition is the same page which is there at page 43. The copy is clear. Rejection order. I request your lordship to read page 59.
Under similar circumstances, we have passed an order.
In favor of the petitioner.
Yes,
May I get the number?
he was appearing.
But he
He has appeared in that case.
he may appear. Even
Whether it is
Show the
identical,
kindness.
we don't know whether it is identical, but from reading we see it is similar.
we seek Mr. Mukherjee's kindness.
I think we think you will get it. In some other case, some lawyer was also.
That is kind of transfer application. Your lordship, application was made.
Yes, the ground for rejection was that it is not transferable.
Transfer.
So, but the facts were more or less identical. So it is better.
In my case, my lord, I was examined. My application was considered. I was examined twice physically and I was found fit. Kindly turns to the report of examination. My lord, page, just now I wanted to place page.
Page?
59. This is a report of 2019, 2014. 25th of September 2014 by the Superintendent of Police, Uttar Dinajpur, to the Inspector General of Police.
What is the date?
25th of September 2014. Last para. In view of the above, you were requested to kindly send the proposal to the Government of West Bengal for consideration of the employment of Tonoy Mondol for appointment to the post of constable on compassionate ground under exempted category, as his family is indigent and deserves immediate assistance for relief from financial destitution.
Everything is recorded at page 41 and 42 of the opposition. You see in that letter which is issued by the Superintendent of Police Uttar Dinajpur, he has recorded the entire history, how things have progressed.
Absolutely. Absolutely. I've seen. I wanted to place these pages, Malad.
Therefore, we are saying we have passed an order in similar circumstance. Considering 10AA applicability of 2016 26 EMP.
Yes. And Malad, may I only place one judgment of Justice Harish Tandon sitting in division bench that in the case of Malad Antara Banerjee, page 91 of the writ petition, where Malad, my case was rejected by the tribunal on compassionate ground. Kindly turns to page 96. As indicated above, the committee, that means the inquiry committee, found that the family needs employment, appointment or compassionate ground of the petitioner and may be considered in this regard. The moment eligibility criteria incorporated under paragraph 6 of the said scheme is found to have been fulfilled or satisfied by the inquiry committee, and in fact, the recommendation was made in this regard, unless there is incriminating materials found in course of hearing by the said authority, and if there is no material to raise any doubt upon the recommendation of the inquiry committee, simply because the said authority formed another opinion, cannot be the ground of rejection of the said application. And the court held, directed to give appointment. We direct the secretary to consider the said application within so and so. And the appointment was given. Justice Bishas was a part of the judgment. ঠিক আছে না
Yes, you had filed a reply before the tribunal.
now before the tribunal on the no reply was filed. Well, on the very first day it was dismissed.
They have already filed opposition here.
Here
What is it? What is your stand?
Kindly see. 2 years is the limitation cost. Because they took place long before 1993. When either about 2 years or 4 years. He has not fulfilled that. Secondly, related cost came a
All these things we have, that is why we are saying everything, same things were argued.
But I tried
Yes,
my level best
limitation.
on the last day, at least 2 months back, when this matter was taken up for consideration. With just, my lord was just sitting with Justice Bhattacharya. I tried my level best, but I could not get that judgment.
Oui, কি?
No, Judge Sahib যেটা বলছেন, which my lord is saying now.
We can't remember all the judgments
Absolutely. It's true.
because
May I request your lordship to pass an order today? It may not be in a judgment format, but may I get for many months I'm waiting for this judgment.
no, that judgment is there.
Neither me
So far as transfer application, I've got the copy.
Yes, so that please share it. We are just not today.
Tomorrow.
No order. It will come on the day. Because everything we have dealt 26 EMP 2016, whether it will apply, because in 2016 that 26 EMP it says matters which are pending, it will apply. Everything we have considered.
Your lordship has considered, my lord has delivered judgments, condoning that age bar, tested up to Supreme Court, dismissed SLP. Again, the department is rejecting on the basis.
Just come with
We
that.
are coming, I have filed at least 2 petitions here.
Get that judgment. There should be no
If these authorities, officers are not,
WST number 6 of 2025.
Get it.
1 second, give me 1 second time. WPST 6 of 2025.
Dated 26th of 2025.
WPST 6.
Just get it. Will not today. It will come on Monday.
Monday.
Yes. Not today. WPSC. It will come on Monday.